All right, good afternoon, everyone. All right, I like that. All right, good afternoon. We're going to go ahead and call this hearing to order. This is the Marijuana Legalization Initiative Statute number 1762. I do want to thank my colleagues, first off, for joining us. With me today is Assemblymember Wood and Ridley Thomas from the Assembly Health Committee, Assembly Rev and Tax Committee. Also, Senator Hill, thank you for being here as well, who chairs the Senate BMP Committee. So, as chair of the Business and Professions Committee, which has regulatory oversight of many of the professional licensing entities in California, including the Bureau of Medical Marijuana Regulation, I hope to have a robust discussion today about this initiative for legalizing the adult use of marijuana. The initiative comes at a time when many states are scrutinizing the feasibility of marijuana as a medicine, as well as a business venture and commercial product. California is one of the leading states to tackle these issues head on. It is also unique because of its varied landscapes and populations. We all know we represent very diverse communities throughout the entire state. We must be cognizant of the effects of medical and adult use marijuana on our environment as well as on our citizens. As many of you know, because of Steinberg's legislation, SB 1253, we are required to hold a hearing when an initiative reaches 25% as opposed to in the past where it had to reach 100%. This hearing really is to provide a forum for the public and allow for public participation. We like to thank all of our panelists for being here. And with that, let me go ahead and turn it over to my co-chairs for a 2-minute brief statement. So who would like to begin? Why don't Mr. Ridley Thomas, why don't you begin?
Thank you, Mr. Salas. Who have helped foster this dialogue. This is of great interest, and in addition to the Steinberg proposal, I think that we have an obligation to the people of California as policy chairs to take a look at this subject matter. It would have been my wish that marijuana legalization find its way through a legislative process. It would have allowed for a better vetting, frankly, than I think the ballot allows for. My great concern, aside from the issues related to the Committee on Revenue and Taxation, are specifically the concerns that I have about legal marijuana dispensaries potentially, if this bill is enacted, becoming the neighborhood blight centers that we've seen in liquor stores. That is my concern. I suspect it is the concern of the people of the 54th Assembly District. And we're going to have some tough dialogue. So those who will be testifying, proponents and opponents, from me you'll hear a great deal of concern about local mitigation of blight, how we make sure that these do not become centers of crime and deteriorated community, and how we work through local governments that frankly may have a less embracing stance than others. There are different positions in this state on the issue. Additionally, with respect to Los Angeles City's Proposition D, which I think passed with 70-some% of the vote of the people and restricted medical marijuana dispensary access in the city of Los Angeles by a significant percentage. I think 90% of the medical marijuana dispensaries were made illegal as a result of Proposition D. There may be other things in Los Angeles in particular that the voters and leaders in Los Angeles County or the city of Los Angeles want to do to restrict these types of dispensary businesses, grow operations, and the like. So it's my intention to tease some of that out with the indulgence of the chairs today and to provide rather strict scrutiny as this bill and that is this proposition goes forward. Thank you, Mr. Chair, and look forward to a very robust dialogue.
Thank you for your opening comments. Senator Hill, please.
Thank you, Mr. Chair, and chairs. Thank you for your leadership on this issue, and thank you to our staffs who I think worked very hard and long and challenging on trying to create a very fair and balanced discussion today, and I think that's wonderful. I want to congratulate and thank them, and thank the participants, the panelists, and the public for coming today to share your thoughts on this initiative. And I hope that our discussion today really results in a balanced and productive policy discussion as we examine the proposal that's before us, particularly given the complexity of the regulatory scheme and the interaction of this proposal with the regulatory framework currently being implemented. And I appreciate the opportunity that this hearing will provide today. So thank you, Mr. Chair.
Thank you, Senator Hill. Assemblymember Wood.
Thank you, Mr. Chair. First of all, I obviously do have a significant interest in this issue. I represent the 2nd Assembly District, which comprises the Emerald Triangle, Humboldt, Trinity, Mendocino counties, where arguably 60 to 70% of all the marijuana probably cultivated in the United States is grown. And as an author of one of the bills related to the MMRSA, where we invested literally thousands of hours on a process that resulted in a Regulatory Safety Act, I have questions about the differences in the AUMA and the product that came out of the legislature and how that will affect my district. So I hope that proponents and opponents can touch on some of the differences and try to convey to me some of the reasoning for why these are a part of the AUMA. But regardless of whether the AUMA passes, the issue of cannabis and its impact on Californians is here to stay. The issue is complicated. The industry is extremely complicated, and the more we learn, the more complicated it becomes. So I look forward to, once again, as my colleagues, a robust and balanced discussion here today as we move forward. Thank you.
Thank you, Mr. Wood. So let's go ahead and just get started, just so that everybody knows and for clarity and to say it up front. We're going to go ahead and try to stick to the agenda, the way the agenda is written, and also with the time constraints in the agenda, just so that everybody does have an opportunity to speak. So first, we'll begin with the nonpartisan overview of the initiative, which we've allowed a 15-minute presentation for. So if Mr. Aaron Edwards, who is the Senior Fiscal and Policy Analyst with the Legislative Analyst's Office, can approach, we'd appreciate that. And we'll begin with Mr. Edwards. So if you'd like to begin, sir, with just a general overview of the initiative, we'd appreciate that.
Good afternoon, Mr. Chair and members. Aaron Edwards with the Legislative Analyst's Office. As you stated, I'm here today to provide you with our summary of our fiscal analysis of the Adult Use of Marijuana Act. In addition, your staff has asked us to provide a brief overview of the trailer bill language proposed by the administration to amend the Medical Marijuana Regulation and Safety Act. So to that end, I've prepared 2 handouts, which the sergeants are distributing right now. I am going to begin with the first handout, which you hopefully have in front of you now. It's entitled Marijuana Legalization Initiative Statute. It looks like this, and this will cover our comments on the proposed measure. So if you'll turn to page 1 of the handout, I'd like to begin by saying a few words about our office's role in the initiative process. So our work on the initiative process begins when an initiative is submitted to the Attorney General for preparation of title and summary. At that point, we're required by state law to produce a joint analysis with the Department of Finance, which looks at the state and local government fiscal impacts from the measure. We have 50 days to complete that analysis, and then the product of that analysis is included in the Attorney General's title and summary that gets placed on the petitions that are then circulated to voters to collect signatures to attempt to qualify for the ballot. The second major part of our responsibility in the initiative process happens after an initiative has qualified for the state ballot. At that point, we are required under state law to provide an impartial analysis for the statewide ballot information voter guide that gets mailed out to registered voters in the state. That includes a description of the measure to help voters understand what it would do, as well as what its fiscal impacts would be. So we are currently in the process of preparing those materials for the voter guide. So with that out of the way, let me turn to the discussion of the measure at hand today. I'll begin with a little bit of a background to help provide some context for our analysis of the measure.
Please.
So the first thing to note is that marijuana is generally illegal under state law. The penalties for marijuana-related activities vary depending on the nature of the offense. For example, possessing less than 1 ounce of marijuana is an infraction and is punishable by up to a $100 fine. In many ways, it's punished very similar to a regular traffic infraction. On the other hand, growing or selling marijuana is a more serious offense and could land someone in prison or jail. In 1996, voters approved Proposition 215, which made it legal under state law for individuals to use marijuana for medical purposes. The measure allowed individuals to cultivate and possess marijuana for medical use, but didn't really address the issue of larger scale production and distribution of medical marijuana. As such, the legislature subsequently approved legislation in 2003, which authorized the formation of medical marijuana cooperatives, which are nonprofit organizations that cultivate and distribute medical marijuana to their members. Cooperatives are not licensed or regulated by the state, but local cities and counties do have the ability to regulate how medical marijuana is grown and sold by cooperatives or individuals. There are some taxes currently collected on medical marijuana in California. State and local governments currently collect sales tax on medical marijuana sales, and there are also a small number of cities which impose additional taxes specifically on medical marijuana. We estimate that the total amount of state and local taxes currently collected is somewhere in the several tens of millions of dollars annually. So while medical marijuana is legal under state law, federal law does not recognize any legitimate medical uses of marijuana, and marijuana remains a prohibited substance under federal law. That said, the current policy of the United States Department of Justice is to not prosecute marijuana users and businesses as long as they are complying with state and local laws, if those state and local laws are written and enforced in a way that upholds certain federal priorities. These priorities include ensuring that marijuana isn't, that minors cannot access marijuana, and that marijuana isn't transported to other states.
Correct. And that's the Cole Memorandum, right?
That's correct, the Cole Memorandum. So with that, if you'll turn to page 3 of your handout, I'll provide a brief overview of some significant recent changes to state medical marijuana laws. So in 2015, the legislature passed laws requiring state agencies to begin regulating medical marijuana. Most of you know this legislation is called the Medical Marijuana Regulation and Safety Act, or the MMRSA. These laws required various state agencies to begin regulating medical marijuana. The table at the top of this page provides a summary of some of the key agencies involved, as well as their primary responsibilities. I won't cover all of these, but just to note a couple of key agencies here. The legislation created a new Bureau of Medical Marijuana Regulation, and they are responsible for licensing and regulating distributors, transporters, and retailers of medical marijuana. Another key agency is the Department of Food and Agriculture, they are tasked with regulating medical marijuana growing facilities and farms. The new laws also require the state to develop a system to track medical marijuana products from seed to sale. Under the new laws, medical marijuana cooperatives are going to be phased out within a few years and replaced by state licensed businesses. It's also important to note that under the legislation, local governments will continue to have the ability to regulate where and how medical marijuana businesses operate. In fact, the legislation requires that these businesses hold both a state and a local license. And with that, I'll move on to the major provisions of the proposed initiative, beginning on page 4 of your handout. So the main thrust of this initiative would be to legalize the non-medical use of marijuana for adults aged 21 and over. We've provided a figure on page 4 which summarizes some of the activities that would be allowed under the measure, along with some restrictions on those activities. For example, under the measure, an individual could smoke marijuana in a private home or at a business licensed for on-site consumption. However, you would not be allowed to smoke marijuana while driving a car, in a public place, or anywhere where smoking tobacco is prohibited. Individuals could possess up to 28.5 grams, or about 1 ounce, of marijuana, as well as up to 8 grams of concentrated marijuana, such as hash. Adults could also give that amount of marijuana away without compensation to other adults aged 21 and over. In addition, adults could grow up to 6 living marijuana plants at a time on their private property, and they could keep the marijuana produced by those plants even if it exceeds the limits I just described on personal possession, as long as it's kept within their private residence. The second key provision in the measure is establishing regulations for non-medical marijuana businesses. So the measure would require the state agencies to begin regulating non-medical marijuana businesses. The division of responsibilities among state agencies would be quite similar to the current division of responsibilities for medical marijuana. In addition, the measure would require that the system that's being developed to track medical marijuana products from seed to sale would be extended to also cover non-medical marijuana products. In addition, cities and counties could require non-medical marijuana businesses to obtain local licenses, and they could set rules for such businesses. For example, they could restrict where those businesses could locate. Cities and counties could also completely ban non-medical marijuana businesses if they choose. Turning now to page 5 of your handout, I'll summarize some of the major tax provisions in the measure. As shown in the figure at the top of page 5, marijuana would be subject to various taxes under the measure. A couple of the key taxes are the establishment of a new tax on both medical and non-medical marijuana of 15% on retail sales. In addition, the measure would establish a tax on the growing of marijuana at a rate of $9.25 per ounce of dried flowers, or $2.75 per ounce of dried leaves. And again, these taxes would apply to both medical and non-medical marijuana. On the other hand, the measure would eliminate the sales tax that's currently collected on medical marijuana, so long as the individual making the purchase possesses a valid government-issued ID card certifying that they are using marijuana for medical purposes. The measure does not change local government's ability to place other taxes on medical or non-medical marijuana. Now, in terms of the allocation of the new tax revenues, the measure does require that some of these state revenues be devoted for specific purposes. In particular, revenues collected from the state excise tax on retail sales, as well as the tax on growing marijuana, would be deposited into a new special fund called the Marijuana Tax Fund. Monies deposited in that fund would first be used to pay back certain state regulatory agencies for any costs of regulating marijuana that aren't covered already by licensing fees. The measure would then allocate a portion of the remaining revenues in the following order. First, $10 million would be allocated annually for a 10-year period to evaluate the effects of the measure. Next, $3 million would be annually allocated for a 4-year period in order to adopt and create methods to determine whether someone is driving under the influence of or driving while impaired, including by marijuana. Turning now to the 6th page of your handout, the next allocation would be $10 million beginning in 2018-19, increasing by $10 million annually each year until 2022-23, at which point the allocation would reach $50 million, and that would continue on an ongoing basis for a grant program to provide services such as job placement assistance and mental health and substance abuse treatment in communities that have been most affected by past drug policies. After all of those allocations have been made, any funds remaining would be then allocated to 3 specific programs. First, 60% would go to youth programs, in particular focused on substance abuse disorder education, prevention, and treatment. 20% would be used to clean up and mitigate negative environmental impacts created by illegal marijuana growing. And the remaining 20% would be used to support programs designed to reduce driving under the influence of alcohol, and marijuana, and other drugs, and for a grant program designed to reduce any potential negative public health or safety impacts from the measure. Beginning in July of 2028, the legislature could change the allocations I just described, subject to certain limitations, such as a requirement that those amendments would further the purposes of the Act. So moving now to page 7 of the handout, continuing with the summary of the major provisions of the proposed initiative. The measure would change penalties for marijuana-related crimes. For example, currently possession of less than 1 ounce of marijuana by someone under the age of 18 is punishable by a $100 fine. Under this measure, such a crime would instead be punishable by a requirement to attend drug education or counseling and to complete community service. In addition, selling marijuana for non-medical purposes is currently punished by up to 4 years in prison or jail. Under this measure, selling marijuana without a license would be a crime that would generally be punishable by up to 6 months in jail and or a fine of up to $500. The measure would also affect individuals who have previously been convicted of certain marijuana crimes. In particular, under the measure, individuals who are serving sentences for activities that would be subject to lesser penalties would be eligible for resentencing. Qualifying persons would be resentenced by the courts to whatever punishment they would have received had the measure been in place when they committed their crime. And then finally, individuals who have completed their sentences for crimes that are reduced by the measure could apply to the courts to have their criminal records amended to reflect the reduced penalty. So turning now to the major fiscal effects of the proposed measure, beginning on page 8 of your handout. Before I summarize the major fiscal effects that we've identified, I just want to start by emphasizing that these fiscal effects are subject to considerable uncertainty, and they could vary pretty significantly depending on a few key factors primarily. First is how state and local governments choose to regulate and tax marijuana. As I mentioned, local governments can prohibit marijuana businesses to the extent that many local governments avail themselves of that opportunity. That would certainly reduce the amount of revenue generated. In addition, it's unknown what future federal policy will be regarding marijuana. As I said, currently the Department of Justice chooses not generally to enforce marijuana laws. Should that change under a new administration or even under the current administration, that could certainly have the impact of, if they were to step up enforcement, that could certainly have the impact of reducing revenues collected from taxes under this measure. And then finally, the fiscal effects would really depend pretty heavily on how marijuana prices and consumption change under this measure. For example, if marijuana consumption increases under the measure, then that would generally have the effect of increasing tax revenues collected. On the other hand, if marijuana prices decline, that could reduce the amount of revenue collected because one of the key taxes is based on retail prices. So with that said, let me now summarize the key fiscal effects that we've identified. The first is it appears there will likely be a reduction in various criminal justice costs. In particular, the costs for state and local governments related to enforcing certain marijuana-related offenses, handling the related criminal cases in the court system, and incarcerating and supervising certain marijuana offenders. These savings could be somewhat offset in the first couple years following the passage of the measure by costs in some other areas, such as for the courts to resentence individuals under the measure. In total, these reduced costs could range from the tens of millions of dollars annually to potentially exceeding $100 million on an annual basis. The second area is we think the measure could result in an increase in marijuana use, and it's possible that that would lead to more individuals seeking publicly funded substance abuse treatment programs, and that could put some additional costs on those state and local programs. However, we would note that such costs could be partially or potentially even entirely offset by additional funding that would be made available for substance abuse treatment under the measure. The measure would also result in costs for the state to regulate the commercial marijuana, non-medical marijuana industry. However, these costs would likely be entirely offset by license fees and taxes collected under the measure. So turning now to the ninth and final page of the handout, the last area of major fiscal effects we've identified is on state and local revenues. Under this measure, the state would receive additional revenue, such as from new excise taxes on marijuana under the measure. In addition, state and local governments would collect existing sales taxes that would be applied to non-medical marijuana sales. This is largely because individuals who are currently purchasing marijuana illegally would begin purchasing it from businesses, legal businesses that would collect such taxes. On the other hand, the measure, since the measure prohibits sales and use tax on medical marijuana, these revenue increases would be partially offset by the loss of some sales and use tax currently collected on those sales. In total, our best estimate is that the state and local governments could eventually collect net additional revenues that could range from the high hundreds of millions of dollars to potentially over $1 billion on an annual basis. I would note, however, that it will those revenues would likely be significantly lower in the first several years after the passage of the measure. And this is because it will likely take some time for the state to issue licenses to businesses and for the industry to really develop and become efficient and competitive with the existing black market. And finally, I would just note that most of these funds that we've just described would be allocated for specific purposes under this measure. So that concludes our summary of the measure. If it pleases the chair, I could go ahead now and summarize the trailer bill language, or we could leave some time for questions.
Let's go ahead and open it up for questions if people have questions. You've already gone 5 minutes over, but it's okay. That just means we'll have 5 minutes less of questions, hopefully. And hopefully we have questions from members and not statements. So, Mr. Dowley, please.
So on page 9 here, where you talk about switching over from legal to illegal, it's not illegal if you have a Prop 215 card. It's illegal to sell. So we've seen in other states where they've passed laws for recreational use of marijuana, where they set up the licenses and the sales tax, and the revenues haven't came in like they expected them to come in to offset all the issues that come up with making it for recreational use. So I know you stated here that you think it's going to take some time, but we have not seen that in other states. So to me, I think that the black market will exist because the price will be lower on the black market because they're not having to pay the amount of fees and taxes that are imposed on them through a legal business. So what's your best estimate? I mean, you say a couple years. Could we expect not to see for many, many years a revenue that we're going to take that we will receive in the state?
Certainly, looking at Colorado and Washington, I think in Colorado, it depends on which estimates you look at, but I think the revenues haven't come in quite as predicted in those states. And I think one of the factors has been the challenge of getting people to convert over, not only just from the black market, but also from the medical market. Those states both had medical industries that were existing, and it has been challenging given the tax differentials between medical and non-medical in those states to get folks to shift over. And I think that's one of the lessons we can learn from looking at Colorado and Washington. And so I think the one thing that this measure does do is apply those excise taxes to both medical and non-medical. And so I think that will probably help to have people transition from the medical to the non-medical industry a little bit quicker in California because they won't have that massive discrepancy in the tax rate. So in terms of how long it's going to take, we really can't say for sure. I think what we can say is, in looking at Colorado and Washington, while they haven't generated the revenue I think was initially anticipated, the trend has been towards increasing consumption in the legal market. The prices are coming down, so we see the prices are becoming a little bit more competitive with the black market over time. And so I don't know we've reached the point where we're sort of at a mature industry where we can say what the ongoing revenues will be in those states, but it does seem that they're moving towards the direction of increasing revenues and moving folks from the black market to the legal market.
All right.
One more quick follow-up question.
Sure.
I'm a farmer, and I'm regulated by the California Department of Food and Ag, and so quality and control of my products that people consume are regulated. In this area, who will be taking care of the quality and making sure that the consumer is getting the product that they are expecting to be paying for?
So under this measure, I think those regulatory duties would primarily fall to the Department of Food and Agriculture. They would be, responsible for licensing growers. Excuse me. In addition, the Department of Public Health would be responsible for licensing and regulating manufacturers. So once that product goes to a manufacturer to be processed to an edible, for example, that would fall under the purview of the Department of Public Health as well.
All right, thank you. And Mr. Daly, that's also on page 3 for each of the different departments and what they would be responsible under. Next, we have a question from Mr. Wood.
Yes, actually a couple questions, but I'll try to be as brief as I can. On page 4, the bottom page 4, you mentioned that cities and counties could require non-medical marijuana businesses to obtain a local license and set such rules for. Now, I practiced dentistry for 27 years. So I got a state license to practice dentistry, but I also had to have a local business license. So is it possible that someone could have a cannabis medical marijuana business and not have a local business license under this statute?
This measure does appear to allow that to occur, yes. Where they would not be required necessarily to have a local business license. Correct, yes. I think that is a difference from the MMRSA, which requires the local license. This measure doesn't necessarily require it. It could be, the locals could require it, but they don't necessarily have to.
But they don't have to.
Yeah.
Okay. And this, another question. And on bottom page 6, you talk beginning July 2028, the legislature could change the above allocations subject to certain limitations, and those are the allocations of the tax provisions. So, kinds of limitations